This is a Current Trends case brief presentation regarding a court case from the Alberta Court of Queen's Bench, JP v. TNP. The case citation is JP v. TNP, 2016, ABQB 613. This case is about whether a mother, TNP, had demonstrated that her two children would face an intolerable and grave risk of harm, under Article 13b of the Hague Convention on the Civil Aspects of International Child Abduction, simplified as the Hague Convention, if they were returned to their habitual residence in Pennsylvania. The father of the children, JP, TNP, and their children, J and L, visited TNP's mother and grandmother in Athabasca, Alberta, in the summer of 2016. TNP refused to return to the U.S. with the children, as she argued that JP presented a serious risk of physical and psychological harm to J and L, and obtained an Emergency Protection Order, or EPO, against JP from the Alberta courts. JP had applied under Article 8 of the Hague Convention to have the children returned to Pennsylvania. Article 8 allows any person claiming that a child has been removed or retained in breach of custody rights to apply to a court for assistance in securing the return of the child. The Hague Convention was signed by Canada in 1980 and implemented in Alberta through the International Child Abduction Act. The United States is also a signatory of the Hague Convention. The primary issue in regarding this case is, did TNP demonstrate that the conditions of Article 13b of the Hague Convention were met? TNP alleged that JP had been mentally, physically, and sexually abusive towards her over a long period, sometimes in front of the children, and involving death threats and a firearm. Although she had only disclosed that there were stress and arguments in the relationship during counseling she underwent from 2014 to 2016, she indicated that this was because she feared child services would remove the children from her custody if she revealed the abuse. She also alleged that when she left J in JP's sole custody when she traveled to Athabasca with L, JP had physically abused him, and that JP had also threatened to kill her mother and grandmother when she refused to give him the children's travel documents. JP denied all these allegations, and said that there were no reports of domestic violence, and that TNP did not fear leaving J in his custody when she traveled. JP also argued that TNP had been prepared to return to Pennsylvania until the end of August, suggesting that she did not fear grave harm. The judge ordered that the children be returned to Pennsylvania, subject to certain conditions and undertakings. These are that 1. JP does not contact TNP. 2. The children should remain in TNP's custody until a Pennsylvania court makes a final decision on custody. 3. TNP must make arrangements for accommodations at a women's shelter following the filing of a petition of protection from abuse in Pennsylvania. 4. JP can only contact the children by Skype. 5. TNP and the children must return on the flights booked and paid for them by JP. 6. JP must not be notified of where TNP and the children are residing in Pennsylvania. And 7. JP must pay interim support to TNP. The decision was based on Canadian case law relating to Article 13b of the Hague Convention. The most important decision was Thompson v. Thompson, which established that if the risk of physical or psychological harm can be mitigated by ordering undertakings, the children should be returned to their habitual residence with such undertakings. In DR v. AAK, it was further determined that it also had to be proven that the foreign jurisdiction would be unwilling or unable to protect the children from further harm. In this case, Pennsylvania has appropriate means to ensure that the children would not come to any harm. In Finizio v. Scopio Finizio, it was established that the court in the children's habitual place of residence should be the one to determine long-term custody of the children. The judge also decided that it was necessary to determine whether the evidence of any alleged abuse was robust. In this case, the judge felt it was not, and that any possibility of harm to the children or TNP could be mitigated by conditions and undertakings. In my opinion, it was unclear whether TNP's allegations were true, or made because she did not wish to return to Pennsylvania. The judge's approach was consistent with the Hague Convention's goal of dissuading child abductions, while at the same time taking a precautionary approach to the allegations by using conditions. It is important to note that the children were not returned to JP, nor was he given physical access to them, owing to the serious nature of the allegations. Rather, the decision forced TNP to return to Pennsylvania with the children, where the courts could consider the veracity of the allegations as part of a final custody decision. This decision was effective in addressing the fact that TNP had illegally kept the children in Athabasca, but also ensured the children were protected from any possible abuse at the hands of JP. Thus, I will conclude with a survey question: do you agree that the decision was a well-balanced and appropriate one? Thank you.